did ask me to put in the record that he expresses his appreciation to his staff, specifically Suzanne Sullivan, who assisted extensively with his preparation for the hearing. And so I did assure him I would put Ms. Sullivan's name in the record. Now moving to panel 3, we are delighted to have with us from the Commonwealth of Massachusetts and the state of New Jersey the following individuals. Ms. Sue Tip Lamb from the Massachusetts Office of the Attorney General, who has been allocated no more than 15 minutes. Mr. James C. Coleman, also from Massachusetts, but the Department of Environmental Protection, also for no more than 15 minutes. Mr. David K. Monroe from the New Jersey Department of Environmental Protection and the New Jersey Meadowlands Commission for no more than 20 minutes. And finally, along with Mr. Monroe, sharing the time is Mr. Robert Severio from the New Jersey Meadowlands Commission. Welcome, and I believe we will start with Ms. Lamb.
Thank you, Mr. Chairman. I am here to speak on behalf of Massachusetts Attorney General Martha Coakley, and thank you for the opportunity for us to discuss this very important issue relating to NET's proposal. Before I begin, I'd like to also address an issue that was brought up by Mr. Moat regarding deferral. I don't believe we should defer the determination in this matter until the Third Circuit rules. First, we believe the district court in the Jackson case was wrongly decided, and that decision is not binding on this board, and it's now on appeal. The parties have briefed the issues, and we believe the matter is now ripe for decision. The issue before the board is whether or not the solid waste processing facility as proposed by NET is intimately related to rail transportation. And before I begin, the layout of the site, the project, the only facility activities that we are challenging is the solid waste processing facility and activities that's happening in the center portion of the development area. They also propose transporting other commodities in other portions of the site, and that we're not here to address those. We're not expressing an opinion on the merits of those activities. We're only addressing on the facility in the center of this development area. And a determination on this issue relating to this facility will not affect NET's proposals with regard to other commodities. I think that I'd like to address that as one of the answers to your questions. And also, we're also just asking the board for a determination on the processing activities, solid waste processing activities, and we don't believe a decision in this instance would have any effect on activities by typically conducted by other railroads. This board have in past decisions, and also the courts have said that transloading is also integrally related to rail transportation, and we have examples of transloading of solid waste in Massachusetts that do just that. They transload, they unload containers of municipal solid waste from the rail car, from the truck onto the rail cars without dumping, without sorting, without baling, or shredding any of that waste. And that facility is located in Allston, Massachusetts. And the state, the Commonwealth, have not asserted a jurisdiction in which they have to get a permit. So that facility was allowed to proceed as a transloading facility. We have not asserted that they should get permit for that. So transloading of solid waste can be done without all the processing activities that's being proposed here. The proposal here is to dump the waste onto a floor, manipulate it, sort it, and then segregate parts of it, and then shred the rest of it, and then maybe even bale some of it. That type of activity, as you will hear from the industry groups, is being done typically by solid waste processing facilities throughout Massachusetts and in the other states also. And they are heavily regulated. Why? Because they generate problems like rats, vectors, litter, odor, emissions, and a whole host of other nuisance problems that could potentially be harmful to public health and safety and the environment. So Massachusetts, in order to become a solid waste facility, you have to satisfy site assignment requirements. That is, there will be a local meaning the local Board of Health and Department of Environmental Protection will be jointly reviewing this, whether or not this facility, the site is actually suitable for this type of facility. They need to look at the needs of the community. They need to look at whether or not there are actually sensitive receptors around the area. That's the first step. And then the second step is the permitting process. The permitting process is a key process in which precautionary measures are actually being developed during this process. They look at the construction and design of the building to see if whether or not the building can handle this type or amount of waste that's being proposed to be processed there. They also look at whether or not there are sufficient controls on runoffs. They look at also whether or not there is any kind of emission controls or older controls that should be installed. They also develop conditions during this permitting process that would set forth the terms by which the facility should be operated. So these regulations are key to ensuring that these facilities will be conducted in a manner that's protective of public health, safety, and the environment. And NET right now, in their proposal, is saying that the proposed activity, because it's located near a railroad, adjacent to a railroad, and it facilitates rail transportation, it should not be subject to any of these laws. And we argue that mere facilitation is not standard in looking at whether or not an activity is integrally related to the ability to transport by rail, because that goes too far. That would allow facilities like a manufacturing facility. It would allow possibly production facility to be springing up along these railroad lines simply because the process in the manufacturing process or the production process could simply facilitate the transport. That type of reasoning the facilitation reasoning has been rejected in high tech, where high tech try to get C&D trucking activities to be within the jurisdiction of the board, and the board has rejected that. That has gone too far. So we argue that the integrally related test has to be more than just facilitation. Here we've shown that the transloading of solid waste does not need to be processed. You could transload containers of solid waste from the truck to the rail. And also, this type of separation of the waste into different waste streams is really akin to manufacturing and processing. This is sort of very to the key to the solid waste processing type industry is that you separate the waste because they need to be handled differently. Once you separate them, once you process them, the requirements that you have need to be handled differently. Like even earlier in the morning, some of the requirements will be facilitating the disposal of it at the landfill. So that is necessary for disposal of this solid waste. It's not necessary for transport. Throughout this process, we raised an issue that they actually generate revenue by separating and segregating, and they actually generate revenue through recycling. During this whole entire process, going back, I don't know, 2 or 3 years ago, when they first came before this board, in the first notice for exemption they submitted, they never mentioned anything about waste. When they withdrew that notice and they actually submitted a petition for preemption, that was the first petition before this board, they never mentioned about waste. As a result, this board issued a conditional authority for them to, authorization for them to proceed, conditioned on the review by the section of environmental analysis. is only during that review process did they find out, or did the community learn that there was actually going to be processing of waste material there. And as a result of that, the board dismissed the petition. Now, this is the third time they come before the board. And throughout this whole issue, and in discussion with the state, they have never said they're not going to recycle the material. It's at the 11th hour, they file a surprise response indicating they won't be recycling. I really ask the board to look into that and see if there is any truth to it. Because I think it's kind of incredible for them to take the time to separate out the valuable steel, metal pieces and the wood, and then just so that they can ship it to a landfill to be disposed of. So in any event, whether or not they recycle, this process really, the process of dumping it onto the ground, separating it, sorting it, and shredding and baling it is not interrally related, because solid waste can be transloaded without this processing activity. Now, and they should be subject to state regulation. The board has asked several questions in the notice of oral argument, suggesting if the board were dealing with mainly the scope of preemption. I would argue that there's no preemption here, and to the extent that there will be considered preemption, the scope of it, I should say, the questions posed raise a whole host of issues about protection of public health and safety and environment issues. First, one of the questions asked whether or not there are any kind of federal laws that apply to processing facilities, solid waste processing facilities. There aren't any, despite the fact that the petitioners had listed a number of regulations. None of those apply specifically to solid waste processing facilities. There is the Solid Waste Disposal Act, the Federal Solid Waste Disposal Act, but that deal mainly with landfills, not processing facilities. And there may be some, for instance, the Federal Clean Air Act that may apply to specific aspects of what they do, that is no substitute for the siting and the permitting requirements that the state has to protect public health and the environment. In addition, the board asked if you find preemption, what if you set up this procedure by which you could set conditions in the authorization to the petitioner and have the state do inspections. That raised several questions. I mean, in terms of, first, is there an authority? Is there authority for the board to delegate some of this enforcement issue to the states? Second, what standards are the states going to be measuring this facility against when they go and do the inspections? Are they going to be standards that the board's going to be developing? They're going to be, if it's going to be the state standards, then it doesn't really work with preemption, analysis. And if it's really the state standards, why shouldn't the state just do the enforcement? Then also, if we do find violations, and you suggested maybe, based on a call from the state that you could, suspend the license or the authority to operate. And I would ask, on what level of violation can trigger that suspension? Because there could be a whole host of violations that may not trigger a shutdown of a facility, but it's sufficient, it still would cause potential for great harm to the environment and the public. So it raises a lot of issues in this arena of enforcement if we do actually have, if you actually find that there is preemption. And I also would say that the volunteer agreements will raise the same issues when the state does not have the power to sanction, to ensure compliance. I would end with, if the board were to determine that there is preemption, and this is that many, and as you know, many more of this solid waste processing facility will set up shop next to railroads. And there'll be many more that will go unregulated to the detriment of public health and safety and environment. And that is contrary to the stated transportation policy that's set out in ICTA. Thank you.
Thank you, Ms. Lamb, and we appreciate you staying right on schedule. We'll now proceed with Mr. Coleman.
Good afternoon. Thank you very much. I am Jim Coleman, the Assistant Commissioner at Mass Department of Environmental Protection, and as such, I'm responsible for the programs that regulate solid waste facilities as well as a variety of other things. Mass DEP has been involved in this case from the beginning for two very simple reasons. First, as Ms. Lamb has explained, we do not believe that solid waste processing is integral to rail transportation and therefore should not be preempted. And second, as a practical on-the-ground matter, if you determine that solid waste processing is preempted, then in my view there will be no government agency in a position to protect the citizens of Wilmington, Woburn, and by extension Massachusetts residents and other states, should this occur in other states, from the potential risks inherent in solid waste processing. And I'd like to focus my remarks on this point. I want to first, though, emphasize that Mass DEP is not opposed to rail transportation or even transporting solid waste by rail. As Ms. Lamb pointed out, we have recognized the right of railroads to transport solid waste and the rail preemption in the case of true intermodal transportation, such as the Alston case. However, solid waste processing, as is proposed here, is a completely different situation. A little bit of background on solid waste processing facilities in Massachusetts. We have 11 currently permitted C&D waste processing facilities, several of which do have access to rail. These 11 facilities processed about 1.2 million tons of C&D in 2006. 3 additional facilities are going through the permitting process now. All of the C&D processing facilities are permitted to handle C&D waste by dumping waste on a tipping floor and then processing the waste by use of various methods, trommel screens, shredders, hand picking, etc. These processing activities yield a variety of recyclable materials, and I raise this because in the previous incarnations of this proposal, recycling was a very important part. It's this morning that we learned that suddenly it's not. But various recyclable materials such as asphalt, brick, concrete, metal, wood, and then the fines that come out from when all this is mixed up are used as daily cover for grading and shaping material at landfills, and that's another revenue source. In addition, C&D processors pull out, as was mentioned this morning, things like propane tanks, cathode ray tubes, which are your old television tubes or computer tubes, which are banned from disposal in Massachusetts. As a result of these processing activities, the amount of material requiring disposal is greatly reduced, and a number of commodities with value, such as metal and wood, are generated, which reduces the Commonwealth's dependence on landfills. And I would reiterate what Ms. Lamb said, that it does strain the credibility to think that this facility would separate out the metal, which can be a very high economic value, and then put it back in the trash and send it to a landfill. I don't know of any other facility that would do such a thing. We permit our facilities by having a site assignment and permitting regulations which apply to all processing facilities, and we have a clear set of rules that everybody understands and allow the facility to operate in a manner which will protect human health, safety, and the environment. While C&D facilities provide a valuable waste management service, Mass DEP has stringent regulations to ensure they do not cause public health, safety, or environmental problems from dust, odors, vectors, traffic, management of runoff, etc. They must also properly manage asbestos materials, which when you take materials, particularly in an old housing stock like in Massachusetts. There's a lot of asbestos in the C&D materials, which when it's dumped and processed comes out into the air, which is bad for the workers and bad for any neighbors. Asbestos is a known carcinogen. So there are very serious potential consequences of this not being properly regulated. We also have an inspection program which includes regular inspections to ensure the facilities are operating in a manner which protects public health. And I would also add that in Massachusetts we have a fee program that all permitted facilities pay an annual compliance fee which supports our inspectors. So for us to, as was hinted this morning, to get in the business of starting to inspect facilities that don't pay a fee does have some potential impacts on our budget. Our concerns are not theoretical. While many facilities maintain good compliance, due, I would argue, to our strict oversight, some do not. For example, at one C&D waste processing facility, which was just recently constructed in Massachusetts in 2002, we have in the first 2 years, we have already received complaints, 11 complaints from neighbors and local officials. We performed 17 inspections at that facility. We observed stockpiling of unacceptable materials that were not allowed to be brought in, failure to inspect or sample incoming loads for impermissible items, failure to maintain records, and creating nuisance conditions, including dust, noise, odor, including hydrogen sulfide, which is that rotten egg smell, which not only smells bad, but actually can have serious health impacts. So facilities, much as they may promise, aren't always in compliance. In such cases, we have a variety of tools, short of shutting down a facility, to bring the facility back into compliance. First, we have notices of noncompliance, which is essentially like a traffic ticket, which says you are in noncompliance and you have to come back into compliance within a certain amount of time. That does take care of most cases. If that doesn't work, we can have administrative consent orders or administrative consent orders with a penalty. Massachusetts does have the authority to, Mass DEP does have the authority to impose administrative penalties when violations are not corrected. And if the facility owner-operator does not agree, they have a right to appeal, or we can issue an order, which they can also appeal. I've gone into such detail to illustrate the key policy and practical reason why federal preemption of state and local oversight is so important to us. If we are prevented from regulating solid waste processing facilities, who will? Who will hold NET, for example, accountable? I do not, with all due respect to this board, I do not believe that the STB is equipped to do so. I do not, as far as I know, the STB does not have standards or regulations specifically for solid waste facilities. As far as I know, you do not have staff to go out and perform inspections or take enforcement actions when necessary. And as I understand your role, it does not encompass strictly regulating such activities. So the question becomes, for me, as a regulator and responsible for protecting public health and the environment and protecting our citizens, whose role is it if state and local governments are preempted? In the case I described, who would the neighbors and local officials complain to? Who would assist them in preventing noise, dust, odors, etc.? Who would protect their right to a safe place to live and work? Unfortunately, I think, should this be preempted, the answer is there would be nobody. In theory, states would maintain their police power. However, with no clear standards and a complete lack of administrative remedies, our only recourse would be to refer a case to the Attorney General and go to court, which this would only make sense in the most egregious situations, not for the run-of-the-mill nuisance that is so common. In most cases, a notice of noncompliance or order solves the problem and the facility does not have to shut down. On the other side, what rules would NET use to know if they were operating properly? Assuming NET wants to be a good neighbor, which I do, what rules do they follow? Without inspectors, who confirms whether or not they're doing it? While we would like to, I've been in the environmental regulatory business for 30 years, we have all learned that we cannot rely merely on promises. Mass DEP is not trying to regulate rail transportation or transloading activities that don't involve activities such as solid waste processing that pose risk to public health and the environment. We know how solid waste processing facilities are supposed to operate. We know the problems that can arise. We know how to help the owner-operator fix them, and we have the enforcement tools to get them back into compliance as necessary. We don't oppose this project per se. We want to make sure that we can do our job, the job that government has to protect public health, welfare, and the environment of our citizens. I wanted to just cover a couple of things. That's the end of my remarks I was going to give that were talked about this morning that I want to put our view first. As was said this morning, NET did offer an arrangement that we did meet with them. I was at that meeting. And they claim that they made an offer and we never responded. That is incorrect. They made, in my view, they made an offer that was very vague. They sent it in writing. We responded to the attorney who sent it to us orally over the phone. When we asked them how would such an agreement be enforced, they had no idea how to do that. They didn't have any answer, and we certainly didn't know how outside of our regulatory framework such an agreement sort of out there in the atmosphere would ever be enforceable. Some comments were made with regard to how perhaps NET's proposals have been misunderstood and we need to be corrected on what they really do. My only response to that would be, how can we understand a proposal that changes so often? We've tried our best, and we spent a lot of time trying to understand each proposal. I believe this is the third iteration of their proposal. That makes it very hard for us to have a reasonable conversation with a proponent that's a moving target. Back to the offer to come into some agreement. They made several promises of good behavior, but they offered no way by which NET could be held accountable. Essentially, they refused to be held accountable to their own promises. And again, for us as environmental regulators, this is a key question. There are, I should point out, that there are several C&D facilities that ship out of state by rail. So I'm not sure, the question was asked this morning, whether or not their facility would replace trucks, and NET, I believe, asserted that it would. I would say this may or may not replace trucks. It may well compete with other rail facilities. I don't think that's possible to project or predict at this point in time. And finally, in response to a question about whether other facilities will also try this exemption if you approve it, I think many will. Why would anyone in any state go through the local authorities and state authorities, which are quite rigorous, which is not to say you're not rigorous, but you're not necessarily so rigorous about solid waste issues, if they can come to you and get a preemption? And that's my big concern. I do think this case may set a precedent. I know I've already heard about other facilities in Massachusetts, other entities in Massachusetts that may want to pursue this route, and I worry that the board may be getting a lot of requests for this and get into a whole area that, I mean, if your choice to get into it, obviously not mine to say, but I can tell you that overseeing solid waste facilities is not an easy job. Thank you very much for this opportunity.
Thank you, Mr. Coleman. And now we'll turn to Mr. David K. Monroe from the New Jersey Department of Environmental Protection.
Thank you, Mr. Chairman. Mr. Saberio is going to speak first for the New Jersey Meadowlands Commission.
Welcome, Mr. Saberio. Please proceed.
Thank you, Mr. Chairman, members of the Commission. My name is Bob Saberio. I'm Executive Director of the New Jersey Meadowlands Commission. It seems to me that the issue that you have before you today has less to do with rail transportation, and it has all to do with solid waste processing and whether it is regulated or not. This has serious, very serious considerations and consequences for the Meadowlands region. 5 miles outside of Manhattan, this 32 square mile area hosts one of the largest urban wetlands in the country, and primarily on the East Coast. Contrary to what the attorney said from NYSNW, it is not the opening credits from The Sopranos, but it is home to the Frank Lautenberg rail station that recently opened up. Unfortunately, what we have today wasn't like this 40, 50 years ago. The Meadowlands region, before the Meadowlands Commission came on, was heaps and mountains of garbage, burning garbage, nasty runoffs, and scars upon the land that are still there today. Since then, the state has been able to come in adopt uniform regulations to govern these sorts of facilities and have exercised their police power that have brought those days to a close. My agency, for instance, was given the responsibility in 1969 to preserve the delicate balance of nature, to ensure proper solid waste management and the implementation of health and safety standards, including building codes. Unfortunately, this has been undercut in recent years by new solid waste hauling operations springing up along the NYS&W rail tracks, throwing up immense two-story high piles of steaming debris without any discernible protections for workers, sending up dust clouds containing unknown materials, and leaking liquid wastes that were found to contain excessive levels of lead, arsenic, mercury, and copper. Contrary to the argument of Mr. Modes this morning, after years of litigation and every opportunity to meet the International Building Code and abide by environmental standards, one of the Meadowlands facilities, still under the NYS&W, still does not even have a fire suppression system, does not have proper air quality measures, and worst of all, under NYS&W's argument, they could choose to allow waste processors on their land to revert back to open piles they formerly presided over, and even further, with further lack of safeguards in each and every one of those situations. The questions that you are being asked today is whether these operations constitute rail operations. We believe they do not. The NYS&W position is clear. Provide us a way for solid waste processing to be carried out so environmental and building code standards can be disregarded. I also like to point out, just as a comment, the characterization of these facilities, I would say that their descriptions were very charitable this morning in the descriptions of the conditions of these facilities. But make no mistake, they're asking you to return us, the people of the Meadowlands, back to a day when waste handling existed in a sort of regulatory black hole. There are real consequences to this. For the emergency responders who may have to rush into a burning facility that has not complied with the building code, or the workers that are in that facility, this is a fire trap, and they have very dire human consequences if something should happen. For the neighbors that are left to ponder the potential dangers of the dust that settles on their houses and gardens, and for the environment with the runoff and the pollution that has been reported from these sites. That's why today we appreciate your consideration in this matter and the potential you have to bring clarity and rationality to this issue. Thank you. I'll turn it over to David now.
Thank you, Mr. Chairman and the board. I'd like to address a couple of subjects, and I'll tell you what they are. I know my time is limited, and I'll try to move through them quickly. But the first, I'd like to discuss just briefly the nature and the scope of the problem that we're facing. There have been a lot of comments about them, but I think the board needs to know what's really happening out in the states like New Jersey and Massachusetts and other places. Second, I'd like to address some of the comments that have been raised by other parties, and in particular some comments made earlier in the hearing. Third, I'd like to address some of the board's questions, and in particular the idea that has been articulated by the chairman that it would be possible to solve this problem by the application of federal environmental law with the help of the states. And finally, I'd like to suggest what the Department of Environmental Protection in New Jersey thinks is a solution to this problem, which balances the issues, the importance of the preemption under the Commerce Clause with the state's police powers, and which also balances the legitimate interests of railroads with the public health and safety, and which I think has the two additional benefits. One that is based upon the state, the board's already existing precedents regarding preemption, and also would address the issue of the regulatory gap, which was referenced earlier in the hearing. But let me start with the problem. New Jersey has had the dubious honor of being in the forefront of the issue of rail solid waste facilities. New Jersey was involved in the high-tech cases, which were before the board. I'm sure you recall. New Jersey has been involved in extensive litigation with NYS&W, the Susquehanna, over five individual solid waste facilities. 7 have in fact been opened. Has been involved in other litigation with other solid waste entities which sought to construct and to operate solid waste facilities that basically have no fundamental protections for the environment or health and safety. And I point you to that picture. That's the picture that Mr. Motes, who spoke this morning on behalf of the Susquehanna, referenced, that he knew we would put up that picture. And that's my favorite picture, because that tells you and that shows you what we're talking about. The problem is that solid waste facilities are being built which have absolutely no controls, or very few controls, and they're being built and operated by people, by entities who claim that they are subject to total preemption under federal law, and in particular preemption under 10501B. And because they say they're subject to total preemption, they say they do not have to comply with any state law, not state environmental law, not state health and safety law, any law. That is the position that they've taken. And these are the kinds of facilities that are being built. Now, this facility, as Mr. Motes noted, has been closed. Okay? It was closed during the pendency of the Jackson case. It was closed after the judge was shown this picture, and the judge was not happy. But as we know, and it was discussed this morning, the Jackson case found that New Jersey's, at least with respect to some of these facilities, New Jersey's health and safety regulations for solid waste facilities is preempted. And so now we're back to the same situation that the Susquehanna Railroad thought they were in when they built this facility. And if they want, they can build another facility just like this, or open this one. That's the problem that we face. Now, this is not a problem that's limited to New Jersey. There are, in New Jersey alone, approximately 15 of these rail solid waste facilities have been built, and more are coming. And there are the same kind of facilities are going to be built in other states as well. It's a national problem. It's a national problem that threatens to undermine and destroy 40 years of regulation of solid waste by the states, because there is no federal regulation of solid waste by the federal government, only by the states. Now, the problem of these rail solid waste facilities is not limited to new entrants. It is not limited. A big problem is that solid waste facilities have figured out that if we can call ourselves a railroad and claim total preemption, we don't have to do anything. We don't have to comply with any law. And there have been a number of those applications made to this board, and the board has noted the problem with those applications and the abuse of the preemption process. But that's not the total story, because the problem extends beyond new entrants. It also includes existing railroads, because that facility in that photo, that was constructed by an existing railroad, the Susquehanna Railroad. It was constructed with full knowledge that there were state requirements which provided for substantive health and safety requirements to protect the environment and the people who work there and live around there. But they ignored those. Okay? They ignored those because they said, we don't have to do that. And because we don't have to do that, we're not going to do that. Now, a number of the commenters, and particularly the rail parties in this case, have filed comments in which they said, well, you know, this is really, this is a new entrant problem, and the board can address this problem by perhaps rethinking Effingham or by tightening up its exemption procedures, and New Jersey certainly agrees that both of those suggestions would be something for the board to consider. But that will not solve the problem, because if the board is able, by those measures, to squeeze off these what we call sham railroads from forming to become railroads simply to avoid state and local regulations. These solid waste facilities and their operators are not just going to go away. What they're going to do is they're going to partner with existing railroads. And when they started partnering with existing railroads, then the board will still have the same problem we have today. Only because of 10906, the board is going to have very limited ability, as far as we can tell, to do anything about it. Because as Mr. Motes, who was speaking this morning on behalf of the Susquehanna, was very candid about, the existing railroads believe that the board has no power whatsoever to attach any conditions or to impose any kind of regulation on so-called 10906 facilities. And while the board may, and as it has been suggested, could attach conditions to the granting of a license or authorization to a new facility, it can't do that with an existing facility. That's the regulatory gap that Commissioner Mulvey mentioned in his dissent in the Staten Island case. And as far as we can tell, no existing railroad, particularly not the Susquehanna, has ever applied to the board for any authorization to build any of these facilities, not including the facility that's in this picture. Now, they also say that we must deal with these issues on a case-by-case basis. And there is some, obviously the board itself has said that the issue of preemption has to be dealt with on a case-by-case basis. But the board can, and in our view, must take a stand here and issue guidance, because this is a problem that is going to, it's not going away. It's not going away for the states, certainly, and it's not going away for the board either. The board will be embroiled in these kinds of cases for a long period of time unless it makes a ruling of general guidance so that people know what the law is. And so we urge, New Jersey urges the board not to take these cases on a case-by-case basis, but to the extent possible, and we think it is possible, to issue broad guidance as to what is preempted and what is not. It is very difficult not to reply to the very many things that were said about the Jackson case, in particular the state has a vendetta against railroads, or that it has an agenda, or that it's seeking to keep rail facilities from opening, and that is just silly, because the state of New Jersey actually promulgated special regulations for railroads, special regulations that exempted railroads from the licensing and permitting provisions that were otherwise applicable to all other solid waste facilities, and instead only applied the same substantive requirements to rail facilities as it does to everybody else. It is not discriminatory. It does not require permitting, and it does not interfere with rail operations. It doesn't say, it's not a NIMBY situation. It doesn't say you can't put your solid waste facility here. It says, if you do, be responsible and operate it in a responsible manner. Now, I can see my time is up, and I would like to, at some point, and perhaps if I would invite a question as to what we think the solution to this issue is. But I will not impose on the board by going beyond my time at this point. Thank you very much.
Thank you, Mr. Monroe and panelists. I'm sure we have questions. I wanted to give the Vice Chairman the prerogative to start if you would like. Vice Chairman Buttry.
This morning we heard testimony from the NET witness that they had made numerous attempts, or some number of attempts to get some kind of response from the state of Massachusetts on their issues and trying to create a dialogue, if you will. And if I heard you correctly, you said that was inaccurate, that statement was inaccurate. And then you said, enumerated, I think, then what you had done to try to be responsive to their requests. Can you enlighten us a little bit on what it was that they were proposing to you that was causing you trouble at the time?
Well, let me just be clear. We did have discussions. They did approach us. What I meant to say was, what was incorrect was that we never responded. We did respond. We responded with a meeting, at least one meeting, and in follow-up telephone conversations between our attorney, who received the letter of October 14th and with the attorney who wrote it. Our concern with what they'd offered were frankly twofold. One was, since we felt that they were not exempt, it wasn't clear to us how far we should go in having a conversation assuming they would be exempt, which is obviously what they wanted to assume. That's one. And even if it turns out that if we are preempted, our concern was, how would you ever enforce such an agreement? And what we asked them was, give us a proposal, give us a framework, give us a structure where, if we go out and conduct an inspection and we find a violation of whatever's in the agreement, how do we get that fixed? What tools does the Commonwealth have? In every other case, we have tools such as notice of noncompliance, we have administrative penalties, we have administrative consent orders. They did not come back with, well, here's a framework where we would be accountable, and here's how we would hold ourselves accountable. They made a promise that they would do a good job, but they didn't come forth with any mechanism, any tools by which they would be held accountable.
Does Massachusetts have any kind of moratorium in effect now in terms of permitting new solid waste facilities?
No, we do not.
You do not have a moratorium in effect. Okay. How many?
Well, I'm sorry. We do have a moratorium on municipal waste combustors.
Incinerators.
Yes.
Okay. So there's a moratorium on those.
Yes.
No moratorium on non-incinerating facilities.
In fact, we have, as I pointed out, we have 11 permitted C&D processors and 3 more in the process right now.
You have 3 permits pending at the moment.
Correct.
But they're not adjacent to a railroad.
I don't know where they are.
And they're not claiming to be a railroad.
No.
Okay. That's it for the moment, Mr. Chairman.
Mr. Mulvey, you want to proceed?
Sure. In the case of Massachusetts and the NET facility, there's this issue of siting this facility. And Representative Bocelli was saying that they don't want this facility in Woburn or in the Wilmington area. They want it someplace else. Is that the view of MassStep also, that this facility should not be built here? It should be built someplace else? And is that really what this is all about, where it's being sited?
No, that is not our view. We have a process whereby a facility, a entity that wants to site a solid waste facility comes forth with a plan and a proposal, and the first step in the process is an application to the local Board of Health. Every city and town in Massachusetts has a Board of Health. And when they make that application to the Board of Health, they submit to the department at the state level what's called a site suitability report, which explains sort of, are there sensitive receptors nearby, are there wetlands, is it where sort of all those site-related things, not the specific operations of the facility, but sort of to the site. The department then issues a site suitability report, an answer, which whether we say either yes, we believe it's suitable, or no, we do not. If we believe it is suitable, then it goes to the Board of Health for a public hearing. If the Board of Health approves it, it gets what's called a site assignment at the local level and then comes to the department for a permit to operate. Our view of this facility, like any facility, is if and when they ever made an application to us, we would take a look at it and make a decision on its merits as to whether or not this was a good site or not a good site. Mass DEP absolutely does not have any kind of prejudgment as to the suitability of this proposal at this location from a site suitability perspective.
But it will be a state decision, not a local decision ultimately? It will be a MassStep
It's
decision?
both. It's both. If the Board of Health says it is, if the Board of Health denies the site assignment, then I believe the recourse is to court.
Okay. New England Transrail has said that, well, they are willing to comply with all the conditions that you would impose on how they operate the facility. Would it be possible for us to bifurcate this thing and say, well, we will regulate, we will preempt the rail aspect of this, the purely rail aspect of it, but the things that go on inside of these sheds, the floor, the dumping floor and all of that, that would be regulated by Mass Step, and that they would be subject to all of your regulations. And would we be able to delegate enforcement authority to Mass Step, or would they have to come back to get enforcement authority from us to our problems or not, to our problems? I'm
not an attorney, so I can't answer that. Sounds like a legal question to me.
An attorney either, so.
Well, maybe we should decide. I guess I would ask the question, in that situation, how would we be able to take enforcement action? If they were in non-compliance, what would the recourse be? Would we have to come back to the Surface Transportation Board every time we had a disagreement and come down here to a hearing with you, and you would adjudicate whether our inspector was right or whether their claims are right? I don't know. I'm having a lot of trouble sort of grasping in mind exactly how that would work. I suppose if you went in that direction, well, I don't suppose we would absolutely try and work with you on it, but I don't see the framework, and maybe an attorney here could provide a framework. What holds them accountable?
The Attorney General is next to you.
I just want to clarify, if I understand your question correctly, you would be preempting the rail operations?
In other words, the operation of the railroad itself, the loading of the movement of the rail cars and those parts of the operation. You wouldn't be regulating that, but you would be regulating what goes on inside the sheds.
In other words, we won't be preempted, that we'll be able to enforce our regulations. I don't see any problem with that scenario at all. And if they choose to proceed with a project, then they will have to comply with state regulations. If they choose not to, I mean, that's up to them. I mean, but the preemption issue should not be reliant upon what they choose to do.
Well, the thing here would be something along the lines of when the cars can be loaded, when the cars can move, those kinds of regulations that sometimes municipalities try to put on railroad, which do affect interstate commerce and the movement of the cars. That would be preempted, but what goes on in terms of the way the floor is maintained, the standards, the health standards, the safety standards, and all of that, we would not preempt that. Is it possible to make that kind of a division, do you think?
I believe so, because the way they have proposed the project is very specific, that they will only do processing within this one central area. And we believe that this that could be a...
The other thing that the New England Transrail has said that they could never sign on to was this whole waste ban. And there was a long list given to us by Representative Michelli about all of these commodities, all these materials, which the state of Massachusetts is trying to recycle and has said that these cannot be transferred at waste disposal facilities, which I think is the kind of facility they will be operating. So would you be precluding all of these materials from coming into this transfer station for this transloading station? I mean, it's quite a long list of materials, everything from batteries to wood to I don't have the whole list in front of me, but it's quite a long list of commodities that would be precluded.
Not necessarily precluded. I mean, if they are proposing to do processing within this facility and they receive this type of material, in complying with the waste ban regulation, they would just have to pick those materials out and then recycle them.
So they would have to do the sorting and processing and recycling by law at the facility. So they say they're not going to do that. They're just going to take the materials and then bale it or shred it and then put it onto rail cars so they can load the cars more efficiently. But they're not going to do any source separation for creating value added. And so.
May I respond to that?
Mm-hmm.
First of all, back to your first question, on the premise that that you elucidated with Ms. Lamb, that we would not be preempted. I believe you could separate out just the waste processing piece from the rest. We're not interested in the rail cars, where they move, how they move. We're interested in the potential impacts from the waste being brought in and handled. To your second question, the way waste bans tend to work is that facilities, solid waste facilities, can either sort them or they can tell people bringing material, don't bring us that. So, for example, we have all the other solid waste facilities have to do inspections of trucks coming in and say this truck has over, like cardboard is a banned material. If your truck comes in and it's 80% cardboard, they say we can't take it and they send it back. There's no reason why that couldn't be done at this facility as well. We're not saying that NET has to do the sorting. They can put that requirement on whoever's contracting with them, like all the other solid waste facilities do, and say, here's the list of materials. You can't bring in loads with more than de minimis amounts of those materials in them.
Okay. To New Jersey, you aware, I'm sure you're familiar with Senator Lautenberg's amendment to our statute. Do you support that as a solution to this problem, where he would exempt municipal solid waste from the processing, from the activities we preempt?
Yes, we would certainly support that, and we think that would likely solve the problem. But I think there is a solution that the board is already, and the board has for a long time found that preemption under 10501B is not total. That the states retain their police powers to regulate on health and safety issues, so long as those regulations don't act as a bar to rail transportation or unduly interfere with it. And so, for instance, the board has clearly said you can't have health and safety regulations that require permit or pre-clearance, because that basically gives you the chance to say, well, the railroad can't do what it wants to do. And so in New Jersey, for instance, under New Jersey's solid waste 2D regulations, there are no such pre-clearance permitting requirements for railroads. Railroads can set up a solid waste transload if they want. Okay? The board has also said that so long as the health and safety regulations are not discriminatory and they don't interfere or unduly burden rail transportation, that they should be complied with, and that certainly makes a lot of sense. I mean, we don't say that railroads don't have to comply with the criminal laws and driver's license laws and all kinds of other, common state laws which apply to everybody and have nothing to do with rail transportation and don't interfere with rail transportation. Now, there obviously, and that's, I believe that's what and I forget his name, but the counsel for NET, I think, was talking about. There doesn't have to be a regulatory gap, because the way in our minds, the way this should work, preemption should work, is that railroads should be required to comply with normal, everyday state regulations that everybody else complies with, unless there's a reason not to be. And no one in this proceeding and in all the papers that I've seen, no one, to my mind, has ever described why a railroad can't comply with these very basic health and safety. Don't dump mercury in the ground or in the groundwater. Don't pollute the air. Everybody else in the state who operates similar kinds of facilities are able to comply with it. Why is the railroad? Is there a transportation reason the railroad cannot do that? I don't know of one.
The railroads are different in lots of areas. They don't have to follow workers' compensation laws. They have their own compensation law system. There's a whole bunch of things. The Railroad Labor Act differs from the National Labor Relations Act. So, I mean, railroads are treated differently from other industries for all kinds of reasons. But
That is true. But
is it also true that municipal solid waste is also somewhat unique? But there's a real concern that if we move away from preemption in this area, that could threaten the ability for railroads to operate their networks efficiently in other areas. Other things will also be challenged. Other transloading operations will also be challenged. Or are you arguing that municipal solid waste transloading is different because of the health and environmental reasons?
So it's different for two reasons. One, because of the severe and serious health implications and environmental implications, but it's also true because, unlike some of the areas that you just mentioned, this is an area that Congress has left to the states. There are no federal solid waste laws. If the board is going to rely on federal law to regulate solid waste stations, there's nothing there. Congress left this entire area to states to handle, and the states have handled it for the last 30, 40 years. And they've done a pretty good job of cleaning up places across the country which looked a lot like that photo. And so, yeah, solid waste is fundamentally different. And no, I read the comments from a number of parties and interveners in this matter that suggest that, well, if the board does anything with respect to preemption, it may lead, it's going to endanger transloading of coal or sugar or anything else. And I don't see how that. And no one has explained how that would happen. But the fact of the matter is, the reason that this is before the board now, and it's been before the board before, and it's before the courts in various places, is because this is a serious problem that has not come up before. And I think the board's existing precedent, which basically says that railroads should be good citizens and should comply with law unless there's a reason for them not to, a transportation reason, that's what they should do. And I think that's the answer to the whole preemption issue.
Thank you. Thank you.
Thank you, Commissioner Mulvey. I've got a few questions. First, let me just recognize and thank Mr. Siberio for being here. I grew up in South Orange, New Jersey,
Okay.
and spent a lot of time around the Meadowlands. Can't say I've actually waded in them, but certainly enjoyed passing them and seeing them. And certainly the work that your commission's done to restore the Meadowlands has been a great success. I've got close family members who spent a lot of time in the environmental movement in New Jersey, and appreciate the work you've done. Let me just put something to rest for you, because I think Mr. Monroe basically answered one of your biggest concerns about fire suppression. To me, that's a classic example of police powers. This board has long recognized the importance of police powers being exempt from preemption. No one's ever been able to really successfully challenge that supposition. So we take that as black letter law, and in my view, a good faith, reasonable fire suppression system that's directly related to protecting human life and safety would be a classic item under there. So if you've got any situation in New Jersey where there's not fire protection at a rail facility that you're concerned about, I strongly encourage you to figure out how to fix that. Let us know how we can help you, because there's nothing here that should stand in the way of that.
Thank you.
So we should just put that aside.
Mr. Chairman, could I just mention something? The pictures of the later facilities, after this one was closed, some additional facilities were built with buildings. Those buildings, those pictures of the clean sites, or they look like clean sites, they don't have fire suppression equipment or capacity in them. They were built that way because the railroad that built them felt that they were subject to preemption, and they don't have to do that.
Well, I can't give legal advice to your constituents, but I would just say talk to your fire marshal, your fire officials, if they've got a good faith, reasonable concern that human life, et cetera, property is not protected against fire. I think I would say you've got a strong police power exemption, and I would think you would fare quite well in protecting your interests there.
Well, Mr. Chairman, any statement from the board, if the board were to address it, would be certainly helpful, because there's real uncertainty about the scope of preemption and whether it even includes fire suppression. And if the board were to give some guidance, even on something as narrow as that would make a big difference, because we do have facilities now today in New Jersey that do not have fire suppression equipment. And as you know, that not only endangers the surrounding community and the workers, but the firefighters who have to respond to fires.
Well, I will say this is the first I've heard of active concerns about lack of fire suppression at facilities. I've certainly been to a number of rail facilities. I've seen, while not there as a fire marshal inspecting for fire suppression, I've certainly seen and had it explained to me that railroads typically, for their own business reasons and insurance reasons, have a lot of incentive to protect their assets and their people by installing fire suppression. And so, if you've got a concern there, you're hearing from the chairman of the board right now that the police power exemption to the strong doctrine of preemption that Congress enacted. And to answer your question about what a wonder it is as to how we could be at this state of affairs, I do commend your attention to the statutes and to Congress, because the law is according to the City of Auburn, Ninth Circuit case, and other significant cases in this area, are, talk about these strong statutory language and the importance of acknowledging the plain meaning of the statutory language, and the word solid waste exemption just aren't there. Doesn't mean we can't potentially figure out a way to get to an outcome here that you might be able to live with, but it's a struggle. And but certainly, if you've got a situation where there's a problem with fire and legitimate police powers and fire suppression being obstructed due to someone saying the word preemption, please let us know, and we'll work with you to get to the bottom of it. Moving along, I guess it was Mr. Coleman, you mentioned the importance of, and we can appreciate this because we operate largely under a fee collection system here. I hazard to guess that this case is not earning, it's not paying for itself, because whatever fee we might have gotten from the NET, I think we've well exceeded that. But so we're sympathetic to the importance of being able to collect fees and do your job. That being said, though, this really isn't about fees for you in your mind, is it? I mean, you go after people presumably that don't pay fees all the time because they're rogues and they're operating out of the system. That's what the taxpayers pay you to do, correct?
That's correct, but one of the things we do is if we find a rogue, we have the ability to issue penalties and bring them into the system, in which case they have to pay the fees they didn't pay. But you're right. I mean, I don't mean to hold that out as a major issue here. It's just another example of what preemption could mean.
And similarly, is it fair to say if, and I'm not speaking for them, but if NET in this case were to offer to ante up whatever fees you normally collect, your concerns would not go away, correct?
That's correct.
So it's really not about fees, is it? I mean,
no, to us, the issue is who's accountable and how do you hold them accountable.
Right. Accountability, I understand.
Correct.
Do you have any idea how many rail facilities in Massachusetts actually ship municipal solid waste or C&D material by rail? I just don't know, so it's not a trick question. I just was wondering if you knew.
Well, I can think of at least 4 that ship by rail. I don't know if there are probably more, but I know of at least 4. I know that about 15% of our solid waste is shipped out of state. I would imagine most of that goes by rail, not much by truck, would be my guess.
So, and are all of those, the other ones that operate by rail, are they all sort of what I would describe as sealed container placed onto a rail track, never opened, or are they more complicated than that?
One in Alston is sealed containers put on the rail yard, put on the rail. 2 of them actually have site assignment and permits. Went through the whole process, and they have a contract with landfills in Ohio, and they ship out the waste to Ohio by rail. So there's no issue there because they didn't request any kind of preemption.
Okay. And obviously, as someone who's dedicated your career, as it appears you have, to protecting the environment, I want to ask you, from a macro environmental perspective, assuming all other laws are being followed, do you think it's better generally for the environment to have more freight, including waste, shipped by rail rather than by truck? Thinking about sulfur and diesel emissions that come out of multiple trucks, and rail typically is run by one engine pulling a number of cars.
Absolutely. I mean, among the other programs I run are our air program and our automobile inspection and maintenance program and diesel idling reduction program. So certainly I'm aware that the more cars and trucks we can get off the road, the better off we are, which is why one of the reasons I said in my opening remarks, we're not opposed to rail transportation by any means.
Okay, thank you. A couple more questions, bear with me. Mr. Coleman, I imagine, in fact I know, but I'll ask anyway, does the Commonwealth of Massachusetts host any U.S. Defense Department facilities?
Yes.
Do you have unfettered regulatory authority over all the activities of those facilities?
We have actually quite a bit of authority over those facilities. I can't go into detail, but I know that we certainly have authority over the cleanup when they are their own equivalent of Superfund surplus sites. And we are working with some of them on what to do with their, a big one on the Cape is they have a lot of water pollution from from explosives and from lead from their practice range that we regulate them on. In fact, we just had a large issue with the Department of Defense over our level of perchlorate contamination water, which comes from explosives. So we have a fair amount of regulatory authority over defense facilities.
Typically, is your interaction with the Defense Department more often than not a collaborative one where you sit down and work out an agreement, because they certainly have certain sovereign